Hi, everyone, and thanks for joining us for PIPS's National Accessibility Week webinar hosted by the Human Rights and Diversity Committee and the Workers Living with Disabilities Caucus. My name is Stacey McLaren, and I'm the National Chair of the Institute's Human Rights and Diversity Committee. We are also joined today by Mary Lysette, Chair of the Workers with Disability Caucus, Eric Langlais, Manager of Labor Relations at PIPS's National Office, and Daniqua Edwards, National Representative for Human Rights at the Canadian Labour Congress. We're happy to be here with you today. Before we begin, we would like to take some time to respectfully acknowledge that our office is located in the settlement now called Ottawa, and it is on the unceded and unsurrendered territory of the Algonquin Anishinaabe people, whose presence here reaches back over 8,000 years. As settlers, it is our responsibility to educate ourselves on the history of the First Nations, Métis, and Inuit people to learn how to respect their cultures, to acknowledge their pain and suffering, and above all, to understand our part in it and take action towards truth and reconciliation. This includes acknowledging their horrific history, ongoing and intergenerational trauma of the residential school system. It is our duty to learn, grow, and do better. I'm hopeful that our journey guides us to a respectful and harmonious future. At the beginning of our webinars, we like to provide you with our equity statement, which clearly outlines our expectations from participants. If you could please take a moment to review the statement that has the link of which has been put into the chat box. As noted, the Professional Institute of the Public Service of Canada strives to create a climate that is respectful, safe, and inclusive. We thank you for being a part of that inclusive space. Today, as we mark National Accessibility Week, we celebrate the many contributions of persons with disabilities in our country and to the labor movement. We renew our commitment to building a fair, inclusive, and accessible Canada for everyone. It is estimated that 8 million Canadians have a disability that impacts their daily lives. Unfortunately, many still face barriers in the workplace. And when it comes to pursuing an education, growing their careers, or getting opportunities to succeed, workers win when we are all included. This week, I encourage all PIPS members to reflect on the ways we can work together to remove barriers, promote accessibility, and secure fairness for every generation. Before I turn things over to Mr. Langlais, I will go over some key information about our platform, Zoom. Due to the size of the group, we have muted your computers to ensure we have the best sound quality for everyone participating. Further, simultaneous interpretation is offered to ensure you can participate in the official language of your choice. Please, we ask you to use the Q&A feature to ask any questions. These can be technical questions or questions about the webinar content. We will have a question period later in the presentation. Please note that this session is being recorded. And now I will turn things over to Eric Langlais, PIPS's Manager of Labor Relations. Eric?
Thank you very much, Stacey, and thank you for inviting me to join you in this webinar. So what I'm going to be looking at today is the role of employment relations officers in seeking accommodation. So for those that might not know, an employment relations officer they're staff of PIPS, and they work towards representing members across the country. We have regional offices in each of our regions that are there to assist and provide support to members that are seeking accommodation, among other things. But today the focus will be on the duty to accommodate. So getting into that, I'm going to look at human rights and the duty to accommodate, where it comes from, how it came to be, and also look at a little bit of the legal framework associated with that, and just go over a few key cases that have come out that have helped steer the duty to accommodate and provide some checklists and criteria to help get accommodation for members that have disability or any other need for accommodation. And then I'll look at the role of the employment relations officer, how an accommodation process works, and how we work with both members and the employer to find a suitable accommodation. Questions we'll save to the end. Tu peux me les demander dans la langue de votre choix. Je peux répondre en français ou en anglais, mais on va attendre aux fins des deux présentations aujourd'hui avec
Okay, the presentation
des questions qui sont posées dans le Q&A.
give you room to ask questions that may arise in terms of adaptation
The
or
duty to
accommodation.
accommodate refers to the obligation of an employer or a service provider to take measures to eliminate disadvantages to employees, prospective employees or clients that result from a rule, practice, or physical barrier that has or may have an adverse impact on individuals or groups protected under the Canadian Human Rights Act or identified as a designated group under the Employment Equity Act. So what that means in employment, the duty to accommodate is that an employer must implement whatever measures necessary to allow its employees to work to the best of their ability. It's there to remove any barriers that might exist for an individual that might have a disability or any other protected ground, which we'll get into in a little bit, and to remove those barriers so they're able to participate fully in the workplace. Aside from that, mostly we're looking at the employment relationship, but unions such as PIPS also has that same duty to accommodate. We're there to ensure that if an accommodation is needed, if you're coming to us seeking assistance from PIPS, we also take into account the duty to accommodate. So if there are specific needs or barriers related to a disability or anything else, PIPS also is obliged to ensure that we accommodate those members' needs. And I guess to go into it a little bit further, sometimes employers have rules, policies, or practices that apply to everyone, but they may inadvertently create barriers for certain people. For example, if a job normally requires a certain uniform to be worn, but it may create a barrier to someone whose religious practices require a certain manner of dress. The duty to accommodate helps work towards identifying these barriers and working with the employer to remove them. So where does all it come up? We got a bit of a definition of what the duty to accommodate is. It comes from the Human Rights Act. The purpose of the Human Rights Act is to give effect to the principle that all individuals should have an opportunity equal with other individuals to make for themselves the lives that they are able and wish to have, and to have their needs accommodated, consistent with their duties and obligations as members of society, without being hindered in or prevented from doing so by discriminatory practices. Canadian human rights legislation recognizes that true equality means respect for people's different needs and requirements. So when I say the Human Rights Act, for federal public servants, it's the Canadian Human Rights Act. A federally regulated employer is governed by the Canadian Human Rights Act. So that duty to accommodate comes from the Canadian Human Rights Act. For some of our members who work in provincial jurisdictions, each province has their own Human Rights Act that is very similar to what we would see in the Canadian Human Rights Act. And the Act itself, it protects from discrimination. There are sections within the Act that explicitly says that someone cannot be treated differently in employment. So the protections that are offered by the Human Rights Act is there to allow for accommodation to occur. Though our focus today is related to members with disability, that is the caucus that we're here to speak about, it isn't just excluded to people with disabilities. The duty to accommodate applies to any of the protected grounds under the Human Rights Act. So race, color, family status, marital status, disability, sexual orientation. These are all different protected grounds that are included in both the Canadian Human Rights Act and the provincial legislations that they're protected. And if there is a need for accommodation under any of these grounds, there is that obligation on the part of the employer. The only limitation that there is to the duty to accommodate is the concept of undue hardship. The employer need not accommodate an employee if it can show that the accommodation would cause the employer to suffer undue hardship. Now, there's no clear definition of what is meant by undue hardship. Like it's not clearly defined, but the fact that it says undue hardship, that means that there is an expectation that there could be some hardship to an employer when in implementing accommodation measures. So it's not. It's very difficult to reach that point of undue hardship, and there's two sections of undue hardship that could come into play. When you're looking at an accommodation, you do need to look at health and safety. And what that means is you look at the risk to either health and safety of the person seeking accommodation, or to that of other employees or the general public or clients that those employees might be serving. So that needs to be weighed in. And it's a bit of a balancing act between the risk and the need to remove those barriers so someone can participate fully in employment. To give an example, and the amount of risk depends on the actual individual situation. So if the worker or the member that is seeking accommodation, if they bear the risk and they're willing to do that, it's a little bit of a different balance as opposed to whether or not it may impact the health and safety of others around them. Just to give a small example, let's say someone that would wear a turban as part of their religious beliefs may be unable to wear a hard hat in a construction site. If they're willing to go ahead and work without that helmet, it may be a requirement as that particular job, hard hat. But if they've decided that they'll bear the risk and be able to practice their religious belief, then it might be borne, and that might be a suitable accommodation to allow them to do that, versus perhaps someone with who's a pilot, doesn't have the greatest vision. That might, if we were to accommodate them so that they could fly, there's a bit more of a risk factor there that needs to be taken into account, and it may be an undue hardship to allow the accommodation because of the health and safety of many people. When it comes to the issue of cost, in our environment as federal public servants, the employer, either the Treasury Board or one of the separate agencies, cost isn't really an issue. I've never seen a situation where a large employer, such as the federal government, could claim that there's undue hardship to be able to accommodate, because they have, almost, say, infinite resources to be able to implement things. So when you're looking at cost for undue hardship, it's more aimed at kind of a smaller business, let's say a small, like, mom and pop type shop, and they're not able to provide wheelchair access to their store. It may be considered an undue hardship if the cost to implement a ramp to allow them to get in would hinder their ability to carry on as a business. So that's a little bit of what undue hardship looks like. One thing that you might see, and I have seen in several instances where members have been asking for accommodation, is an undue hardship would be they can't create work specific for an individual. So if someone has medical limitations that prevent them from doing the job that they own, and they need to find something else that would be more suitable to their limitations, the employer is not obligated to create work as a measure of accommodation. So that could also be considered an undue hardship. But it's very difficult for the employer to argue undue hardship when it comes to accommodation. So while the various human rights legislation and also the PIPS collective agreements, all PIPS collective agreements do have a no discrimination clause. Just a point of fact that it is contained in our collective agreements. So the employer cannot discriminate against our members based on the collective agreement, in addition to the human rights legislation that's there to protect our members. But there also have been many cases. So with the duty to accommodate, often, we don't always get an agreement with employers, and matters have to go through the court system, or either arbitration. The cases listed here have gone to either the Federal Court of Appeal or the Supreme Court of Canada, and decisions have come out. So there's been a few key decisions that have come out that kind of help solidify the duty to accommodate and discuss certain aspects surrounding it. So the Mayoran decision is one of the key decisions as it relates to the duty to accommodate. Just to give you a little summary of what that was about, Tawny Mayoran was a female firefighter in British Columbia, had been on the job as a firefighter, doing the job perfectly well. The employer implemented fitness standards. There was, I guess, an incident that came out, and they required that firefighters have a certain level of aerobic fitness capacities. So they developed a running test for the firefighters, and they had to meet a certain standard to be able to keep their job. So what happened was Ms. Mayoran was not able to successfully meet that standard, and they ended up firing her from her position. So it went through the court system, and what they looked at is what called was this test to assess physical fitness appropriate, and is it a requirement of the job? So that's what's meant by a bona fide occupational requirement. So they looked at the test as it was, and they determined at the Supreme Court of Canada that it wasn't directly linked to the work that she was doing. Like, there's no correlation between being able to run, 2.4 miles in a certain amount of time versus the ability to being able to fight fires. So the decision came and said that it came up with a test where certain requirements, such as, a fitness test, has to be directly linked to the work that it's been done. So that was a very important decision. The Grismer decision, another one that went to the Supreme Court of Canada. There's a gentleman that had some vision impairment. He did not have the peripheral vision, so his driver's license was canceled. Even though he had developed a system of mirrors that kind of took away that barrier of his vision impairment. And the Supreme Court of Canada found that they failed in their duty to accommodate, and eventually allowed him to take the driving test for his license using the system that he had created to accommodate himself. The Johnstone decision is related to family status. But it's a key decision. We are starting to see a little bit more requests for accommodation as it relates to family status. Ms. Johnstone was worked for CBSA, was a border guard, and they required all employees to work rotating shifts. So during day shift, and then they would have night shifts. But Ms. Johnstone had childcare requirements. She, did everything that she could to try and secure a requirement, but was requesting that she be able to work straight days to be able to meet her duty to care for her child. And again, that was a decision where the employer had failed in their duty to accommodate by not allowing her to work straight days because of her familial obligations. And just this final point on this slide it's a very important one, because it's what employment relations officers use when they argue grievances, either at arbitration. It's what they look to be able to prove. So when you file a grievance for a failure to accommodate, any grievance for that matter, usually the employer or the grievor, the member, is on the hook to prove that grievance, right? We're filing a grievance that the collective agreement has been violated, and we bear the burden to be able to demonstrate that there was a violation. When it comes to duty to accommodate, it's a little bit different. The first thing we have to do is to demonstrate that there was on its face discrimination. So the employer failed to accommodate. They have to show that there is a characteristic protected from discrimination under the Human Rights Code. So in the case of a disability or a duty to accommodate, that would be the characteristic that discrimination occurred, that they experienced an adverse impact with respect to that service, whether the person was fired because that there has to be a detrimental impact, and that detrimental impact was based on that protected characteristic. So you need to show that there was a protected characteristic, so a disability, that there was an adverse impact in their employment, they were fired, and the reason why they were fired was based on that disability. So that would be the part that the griever would need to be able to support at arbitration. And then after you prove that on its face that it was it would be deemed to be discriminatory, the burden then flips over to the employer to prove that they did not act in a discriminatory manner. So it's a little bit different than the usual grievance process, but that's a little bit where the legal framework comes from. So there's been a lot of cases that has gone to arbitration and through the court systems about the duty to accommodate. So that's just a little bit of what we look at when we're speaking to members, and the duty to accommodate and everything else. This is the framework that we use to kind of steer things into that direction. All right, so now that we kind of went over quickly where the duty to accommodate comes from, the legal framework and everything else, I just wanted to look at what the process of accommodation looks like. When it comes to workplace accommodation, it is a very big part of the employment relations officer's role. We do get a lot of members coming forward to us requesting accommodation, or telling us that I've asked for accommodation, my employer is refusing. We saw tons of it with the vaccination mandate. We got lots of requests for accommodation that we assisted members through who had either a medical-based issue with the mandatory vaccination, or also religious-based. The most common things that we see, even though all those protected grounds are subject to the duty to accommodate, the most common that we see would definitely be disability, but we also see a lot of religious accommodation requests, and family status is another one, especially now that we're in that I think they call it the sandwich generation, where people are caring for young children and also caring for elderly parents. They have a lot of obligations, and so we do see a lot of requests for accommodation that we assist members with. The main thing that you need to know about the process is it's a three-part process, or three-party process, sorry. The employer has a role to play, the employee or the member has a role to play, and also the union. And I'll get into the roles of each party there in the next slide. So in the employer's role, they review policies and remove any discriminatory barriers. So they need to develop and implement policies that aren't discriminatory. They inform employees of their rights to accommodation. They inform their managers of their responsibilities. They develop duty to accommodate policies. And when it comes to individual accommodation, they obtain necessary information to assess what is needed as far as an accommodation, and implement those accommodation measures. On the part of the member or the employee, they're responsible for making their accommodation needs known. An employer might have a hard time determining that accommodation is needed if the employee doesn't tell them that it's needed. Sometimes there is a duty, if it's reasonable, that the employer should be aware that an accommodation is necessary, that they do have a duty to inquire. But for the most part, the employee needs to be able to tell the employer that there is a need for an accommodation, and they're also obliged to participate in the process, act in good faith, and to participate and cooperate in the process, and that might be including sharing of information, providing medical information if that is necessary to be able to implement accommodation measures. And from the union's perspective, PIPS's role is to inform members of their rights and responsibilities when it comes to accommodation. We're there to advocate on a member's behalf and make sure that the accommodation process is done fairly and in good faith. And we also represent members through the grievance process if the employer doesn't act accordingly. So the first step when you're looking at accommodation is to make that request directly to the employer. Usually that goes to the immediate supervisor. The union PIPS does play a role in accommodation, but sometimes it's as simple as that. If a member will ask that they need an accommodation, it's easy, straightforward. You have an employer that's considerate and cooperative, and the accommodation needs get implemented without any intervention. That's the easy case. That doesn't always happen. Sometimes it does. I'm sure there are plenty of accommodations out there that do take place where PIPS doesn't get involved at all. But usually what happens is a member will reach out to their employment relations officer or a steward in their workplace that they're comfortable with, and they assist them with their need for accommodation. And usually when a member reaches out to us, we talk about the situation, get an idea of what their issue is, where an accommodation might be needed. We would explain the accommodation process, what's required of them, and how we go about getting that. Some of the questions that you might see an ERO ask a member would be, have you asked for accommodation? Back to that first step, you need to ask for it if you want to be accommodated. What was the response you received? Did you get, crickets? No one responded to you, they ignored you, or did they provide you something that might work, but they didn't fully accommodate everything that you needed? Another thing that we'll ask is, what are the functional limitations? And what that means is medical information that supports the different things that the barriers. It's identifying the barriers. Usually that's supported by medical from your physician. And when it comes to that, I think I'll get into it in the next slide a little bit more in depth, but I just wanted to make it clear that functional limitations are things like, certain amount of weight that they can lift, can only lift 10 pounds, can't raise their arm above their shoulder, things like that. The employer is not entitled to any diagnostic information. They're not entitled to any medications you might be taking. They're not entitled to any of that. What they're looking for is what is needed, whether it's a physical limitation or a mental limitation, more cognitive or anything like that. Those are what is required, and that's what needs to be shared in the conversation with the three-party process. And also, the employee has a duty to be open about their needs. Accommodation is never static. Often, we don't really know exactly what is necessary, and we'll try, different things will be tried. Okay, well, maybe we'll try this, see if it's working. You might find after a while it's not working anymore. The disability becomes more severe, and more accommodation measures need to be implemented. Or after a while it was only a temporary accommodation need. The person has recovered from an injury or an illness, and there might be a need to review. So I just wanted to comment that it's never static, and it's very important for the member to communicate that to their employer. If something's working, that's great. If they find we tried something and it didn't work out, well, then adjustments need to be made so that those barriers are removed and that the accommodation can properly happen. Okay, so functional limitations are a big part of the accommodation process, and as I mentioned earlier, it's not a diagnosis or anything personal. It's just what is what is needed to be able to have the barriers removed so that the person can work as any other employee. One thing I'd like to note about medical information, that can be one of the trickiest parts of the accommodation process. You know, you see your physician, they know that there's a need for an accommodation, but they're not often clear in terms of what employers needed. You know, doctors are there to, you know, cure illnesses, let's say, or, you know, to treat to treat you. They're not in the business of writing letters to employers, so that it can sometimes be difficult to get exactly what is needed. Sometimes a doctor will provide in a medical note an accommodation measure as opposed to a functional limitation. For example, I often see a medical note where the doctor has written that this member needs to work from home. Well, working from home is an accommodation measure. It's not a functional limitation. So what we'd be looking for in that situation, just as an example, you know, requires a quiet work area, free from distraction, an ability, a spot where they can take breaks throughout the day, something along those lines, where, you know, the easiest to see accommodation measure would be working from home, but that's not what employers work with. They work on those limitations, and then they try and impose accommodation or implement accommodation measures so that those limitations are met and the barriers are removed. Yeah, so that's very important. When it comes to medical information, the preference that we always have is to use information from your personal physician. It's always the best source of information. They know you. Generally, you know, you have a history with your doctor. But sometimes, as I mentioned, it can be difficult, and sometimes we just aren't able to get that medical information, so we know exactly what it is required so that member can be in the workplace and be there safely. So there may be instances where an outside medical, like an independent medical examination, might be necessary in order to get those limitations. And the employer might also send a functional abilities form or a letter to the doctor if they haven't received all the information that they require. So once we've determined what the functional limitations are, that's when you meet and discuss with the employer how we're going to impose the accommodations in the workplace. So that can, there are a lot of, this is an exhaustive list. There's many different measures of accommodation that can be in place, but like we can look at the duties and tasks, look at physical demands, workspace, workstation equipment. You know, we might need a sit-stand desk. We might need to look at ergonomics. If someone's easily distracted, or, you know, requires like quiet space, like I've seen, you know, higher walls and a cubicle, that sort of thing, so they're not distracted by kind of people walking by in the office. Different software that might be necessary and that sort of thing. Perfect or reasonable. The duty to accommodate speaks to reasonable accommodation, that it's fair, proper, suitable, appropriate, and rational. So it's not always the perfect accommodation. It needs to be suitable. So that goes back to, you know, it might be reasonable to work from home. That would be an accommodation that would meet all those limitations, but the employer could potentially accommodate those limitations within the workplace. So it's not always the preferred choice, but it needs to be reasonable. And so through the accommodation process, there might be situations where agreement or solution can't be reached. Or there may be instances where the employer just refuses to accommodate altogether, or they only provide a portion of what's needed in the accommodation. So in that situation, that's where the employment relation officer can use some of the recourse mechanisms that we have available. And there are two. You can file a complaint under the Canadian Human Rights Act or a grievance under the collective agreement. Generally, we wouldn't file a human rights complaint because the powers of the Human Rights Commission have been given to the arbitrators that would look after grievances filed by the Federal Public Service members. They have the same powers that the Human Rights Commission would have, and the Human Rights Commission always looks at all other avenues be exhausted before coming to a human rights complaint. So usually our first option would be a grievance. We go through that in that grievance process. The employment relations officer would advocate on your behalf, and then they would help you through that process to ensure that you do get accommodation. And how to contact an ERO. Each of the regional offices are listed on the PIPS website. For whatever region you're in, you can just look it up and reach out to that office should you need assistance in getting accommodated. Okay, thank you.
Hey everyone, thanks Eric for that presentation, and thanks to all the PIPS team for inviting me here, and for everyone who worked really hard to bring this webinar together. So as you all know, it's National Accessibility Week, and the theme for this week is Forward Together, Accessibility and Inclusion for All. And as Eric indicated in his presentation, accessibility can be looked at through many different angles, but for today, we're going to focus on it through the lens of disability. You can go to the next slide. So today we're going to cover the following items. We're going to go over some terms and key concepts to understanding access and inclusion. We'll bust some common ableist myths that employers hold about workers with disabilities. And we'll look at some of the ways that ableism unfolds at work. And finally, we'll discuss how folks can demonstrate allyship and solidarity with workers with disabilities. So here are the terms and key concepts we're going to go through. Ableism, person or identity first language, microaggression, intersectionality, and of course, disability. So ableism is the discrimination of and social prejudice against people with disabilities based on the belief that typical abilities are superior. At its heart, ableism is rooted in the assumption that disabled people require fixing and defines people by their disability. And throughout this presentation, we'll keep coming back to this concept and discuss how it impacts workers. You can go to the next slide. So person first language. So in the disability community, some people prefer person first language and others prefer disability or identity first language. What's important to know is you should check in with folks to see what they prefer. Person first language places the person before their disability or condition. So an example is me using the term person with a disability or person with a visual impairment. Some prefer this language because historically and still today, individuals and systems have reduced people with disabilities to be completely defined by them in a very dehumanizing way, and ignores their contributions, strengths, and capabilities. So in contrast, some prefer identity first language, or some people refer to this as disability first language. So it uses the name of the disability as an adjective in place of the phrase a person with. So for example, disabled person or autistic person. Some people who prefer this language believe that separating their personhood from a trait suggests that the trait is inherently negative. So they might use identity first language also because they feel that the disability is a core component of their identity. So personally, I identify as a disabled person, but I will use the term person with a disability until I confirm with someone what they prefer. So with that said, you might hear me inadvertently switch back and forth between those two terms throughout my presentation. So microaggressions, these are also very important to understanding issues of access and inclusion at work. So microaggressions are the everyday, subtle, intentional, and sometimes unintentional interactions or behaviors that communicate some sort of bias towards historically marginalized groups. Those who commit microaggressions might not even be aware of them. And despite their name, the evidence shows that they are incredibly damaging to those on the receiving end. So here are some examples of ableist microaggressions at work. And you can see that all the individuals on the screen are incredibly displeased and embarrassed. So the first one is, "You don't look disabled." This comment diminishes the experiences of people with invisible disabilities. It implies that there is a universal image of what a person with a disability looks like and how they should act. And this microaggression is also damaging because it perpetuates the idea that only certain disabilities should be considered and accommodated, which, as we'll discuss later, is a common way that employers discriminate against workers with invisible disabilities. Another microaggression is, this is just the way we do things here. So this phrase prioritizes tradition and habit and dismisses requests to accommodate or change to make the workplace more accessible. It can have the effect of dismissing the needs of workers who are encountering barriers. And the last one I've listed here, but certainly this is not the last example of an ableist microaggression. So everybody gets tired. This phrase tends to be used in response to a person with a disability explaining their symptoms, impairments, or needs. The subtext is that, everyone at some point deals with the symptom that the individual is describing, such as being tired, and everyone doesn't need to seek, accommodation, support, or resources. It's an extremely disrespectful and uninformed comment. The implications too are that the person with the disability does not need to be taken seriously, and that they just don't really need support because it's not serious. Like everyone has that issue. And you can go to the next slide. So intersectionality, you'll hear this phrase just a lot. So I thought it was good if we just break it down. So in 1989, legal scholar and writer Kimberly Crenshaw coined the term intersectionality to describe how different systems of oppression, for example, ableism, racism, and sexism, can overlap to create interdependent forms of disadvantage. So I've used this definition here on the screen from Merriam-Webster because it uses plain language without undercutting or misstating what intersectionality is. Oftentimes nowadays, even among well-meaning people, it's used as an adjective for diversity, but that's not what it's supposed to be. It's all about systems, not identities. So a good example of Crenshaw's theory is looking at the experiences of Indigenous people with disabilities. So in Canada, people with disabilities regularly report being dismissed and disrespected when they access health services. The largest portion of human rights complaints across the country are because of disability discrimination. However, Indigenous peoples with disabilities also encounter ableism, settler colonialism, and anti-Indigenous racism. And these systems overlap in devastating ways. For example, in 2008, Brian Sinclair, an Indigenous man who used a wheelchair, died while waiting 34 hours for care in a Winnipeg emergency room. An inquest found that the hospital staff assumed he was homeless, coming in from the cold, or was drunk and sleeping it off. Subsequently, a 2017 report titled "Ignored to Death" concluded that racism within the healthcare system caused Sinclair's death. And there are also additional important layers to this. Indigenous women with disabilities can also encounter overlapping misogyny, settler colonialism, racism, and ableism when they access services, again, with devastating consequences. The Ontario Human Rights Commission site has an excellent article touching on these issues, titled Why It's Dangerous to Be Indigenous and Disabled in Canada. And in the interest of time, I'll place it in the chat after my presentation. So now let's get to definition of disability. So there are several definitions of disability across Canada, and they change depending on the legal context. However, I'm going to use this definition provided by the Accessible Canada Act because it's very comprehensive. So it defines disability as a physical, mental, intellectual, learning, communication, or sensory impairment or functional limitation, whether permanent, temporary, or episodic in nature, that in interaction with a barrier hinders a person's full and equal participation in society. We can go to the next slide. So there are a few things that I want to highlight about this definition because they're really important. So the first thing to note is that there is not a prescribed list of disabilities. It doesn't, the ACA does not list a bunch of medical conditions and say, if your condition isn't on this list, then you're not disabled. Instead, the definition focuses on potential conditions, impairments, or functional limitations, as emphasized in Eric's presentation, that can impact our bodies, minds, how we communicate, process information, and more. And next. So this definition also recognizes that disabilities can fluctuate. They can be permanent, or someone could have a sustained or temporary impairment, such as a broken bone or a whiplash. Disabilities can be episodic in that impairments and symptoms associated with them fluctuate or change. We can go to the next slide. This definition also recognizes that disabilities are not just about the condition or the impairment, but they're also about an interaction of those impairments with barriers. So the Accessible Canada Act essentially defines a barrier as anything that hinders the full and equal participation of persons with disabilities in society. Barriers are wide-ranging, and they can create and exacerbate impairments that exist and are associated with disabilities. So here are some examples of barriers, and I'm sorry, I see that they're cut off. The last one there is just the refusal to change systems and practices. I think that's what it says. So I won't go through these in the interest of time, but I'm also happy to explore some further during the Q&A session. But as you can see, barriers take many forms. And they're important to consider at work and in our communities. And at the end, I'll put a link to an article on best practices for accessible virtual events. These are things that you can consider in, for work meetings and events and things like that. So I've talked about a lot, so let's just sum it up. In Canada, disability is broadly defined using a social model that factors in a combination of a person's impairments, functional limitations, and barriers that create or exacerbate limitations. They can be permanent, temporary, and fluctuating. They're not always visible or apparent. Barriers at work within our communities can be disabling. Experiences of ableism and disability can vary depending on other identities people hold. As well, ableism can be perpetuated overtly and unintentionally. So now we'll talk about disability at work. Folks with disabilities experience disproportionate employment and pay disparities. Stats Canada reports that the unemployment rate for working age people with disabilities is almost double that of the same rate for the same age group, or sorry, it's almost double the rate, the unemployment rate for the same age group without disabilities. And numbers actually just released today by Stats Can further indicate that among persons with disabilities in that working age group, so 25 to 64, 42% of that group who was unemployed could be classified as having work potential. So it's not necessarily just a question of because they have a disability, they're unable to work. So key factors that contribute to the disparities, employment and pay disparities, are unmet needs and unmet accommodation needs and discrimination. And now we'll talk about the ways that ableism manifests within workplace through attitudes, structures, and practices. So these three are common myths that employers hold about folks with disabilities. First, that accommodating workers with disabilities is too costly. Second, that people with disabilities have lower job performance. And third, that there are few working age people with disabilities. So on the first myth, research actually shows that accommodations often cost little or no more than a one-time cost of up to $500. Furthermore, they help retain employees and help eliminate costs associated with training new employees. And moreover, and I would say most importantly, this myth is dangerous from a human rights perspective. Eric brought up the Grismer case. So in that decision, Justice McLaughlin, as she then was, cautioned that, quote, while in some circumstances excessive cost may justify a refusal to accommodate those with disabilities, one must be wary of putting too low a value on accommodating the disabled. It's all too easy to cite increased cost as a reason for refusing to accord the disabled equal treatment. On the second myth, studies show insignificant differences in productivity among workers with disabilities. And furthermore, it's important to consider that having an inaccessible workplace obviously sets people up to fail. Unmet accommodation needs are a key contributor to the employment disparities that workers with disabilities face. And on the third myth, employers often underestimate or are unaware of how many job applicants or current employees live with disabilities. The most recent Canadian survey on disability shows that about 20% of working age Canadians report living with disabilities. So I'm going to try to zoom through these in the interest of time, but essentially in fall 2020, the CLC partnered with Western University to conduct a bilingual national study on workplace harassment and violence. Thousands of workers participated through a survey and through interviews, and there was a lot of participation from federal public servants. And I will provide the report in the chat afterwards. It's really good and has a lot of important stories that need to be told about harassment and discrimination against workers with disabilities. Overall, folks reported a lack of awareness and misconceptions about disability at work, opaque accommodation processes, where workers who requested accommodations were left without response for lengthy periods of time. Workers also reported harassment during medical leave. There could be constant unnecessary communication and repeated sort of get better soon messages, but from management and in a way that communicated irritation and pressure to return to work as soon as possible. Workers also emphasized a misplaced responsibility to maintain healthy work habits, where the employer focuses on resiliency training and telling workers to engage in wellness and just basically manage their work-life balance on their own, while ignoring that the employer obviously has a key role in creating a culture where it's feasible and safe for employees to be well. So impacts. So this is again also from our research with Western U. So when an employer engages in ableism, rather than seeing an opportunity to work with their employee to provide support, this can have far-reaching impacts on the employee and the workplace. Undoubtedly, workers with disabilities are most impacted by ableism. And as you can see, it has devastating effects on their physical and mental health and can lead to job loss. But it's also important to highlight that ableism at work hurts non-disabled workers and the wider workplace environment. Workers in all our diversity need flexible, accessible workplaces that can adapt to our realities. Some need flexibility for childcare responsibilities. Others need adjustments for changes associated with age or body functions, workers who are experiencing andropause, menopause, menstruation, those folks need some adjustments and adaptability. And then, of course, workers need accommodations and supports or flexibility for their disability. So when employers collaborate with unions and workers to create accessible, adaptive work conditions, it truly benefits everyone. And so with that said, everyone has a responsibility in advocating for workplaces that are accessible and inclusive. Folks with disabilities are your colleagues, whether you know it or not. As workers, we all benefit from coming together in solidarity to improve working conditions. And importantly, anyone can acquire a disability. Impairments and functional limitations can arise suddenly or can be acquired over time due to age, stress, and other circumstances. A work environment that is accessible ensures folks can keep working when their abilities change. Because of the time, I'm just going to skip the next slide. But if people have questions about some of the things that unions are doing to support workers with disabilities on a systemic level, we can chat about that in the Q&A. So with what I want to emphasize with this slide is everyone can take small but important steps to tackle ableism at work. For ally, A stands for acknowledge and respect individual abilities, needs, and experiences. L, listen to and learn about different disability types and diverse experiences of ableism. As well, it's important to leverage your influence to promote accessibility and inclusion. And finally, it's important to yield the floor to folks with disabilities to help identify and eliminate barriers. And I also just want to add that understanding all the facets of disability solidarity can feel like a lot, but each of us are learning new things and how to work in solidarity with workers whose experiences are different from our own. And what matters is the desire to learn, improve, and to listen. No one always gets it right, but the sincere desire to improve and implement meaningful follow-through are what's critical. And finally, I just wanted to provide some key takeaways for workers with disabilities. Barriers and ableist attitudes and practices within the workplace can take a serious toll on your physical and mental health. As the CLC's research has shown, the accommodation process itself can be a source of trauma and harm. These systems should not be navigated in isolation and support. So here are some important reminders. One, you're not alone. Many in the workplace are living with disabilities, whether accommodated or not, and visible or not. Two, there is no shame in seeking accommodation. Your accommodation needs are truly about how you can be the most effective worker. Everyone deserves the opportunity to demonstrate why they were hired for their job. As well, it's critical to seek support and solidarity from your union to navigate the accommodation process. And this is actually accidentally missing from the slide, but it's important to document incidents and concerns as they occur. It's not only good for you in terms of keeping track of your experiences at work, but it can also help your union assist you more effectively. And finally, to the best of your ability, please take care of yourself. Use resources and benefits that are available to support your physical and mental safety when you're navigating these systems. And that's it. Thanks for listening.
Thank you, Daniqua. As you can see, we are running short of time, so we will only be able to take a few questions. And going through, we are taking all questions and we will provide answers if need be. And if you have further questions that you haven't been able to ask yet, we ask you to write bettertogether@pips.ca. Now, looking into the questions, one of the ones that we found, what if my employer requires medical info and I have no doctor? So Eric or Daniqua?
Yeah, that can pose a problem, as generally we need to have that medical information to be able to support accommodation. That would be a discussion you have with your employer, and let them know that. Sometimes they might be able to find you a practitioner that would be able to do an assessment, like an independent medical exam, where there are clinics out there that are available that they might be able to help. You might be able to go to like a walk-in clinic, which isn't ideal. And I know that there's definitely issues with that. It would definitely, not really being able to answer it too well, but be something that you'd want to talk with an employment relations officer to have that conversation with the employer, you know, to explain that situation, that you don't have a personal physician. It will be difficult to get medical information and work out a way to kind of deal with that. But there are options out there that might work to get those limitations, because they're key in getting the accommodation, because they want to make sure that they're removing barriers and providing an accommodation that makes it safe for you to do the work. They don't want you to be put in a position where you're not being properly accommodated. So that would be an obstacle you'd have to get around, and work with your employment relations officer, who will, you know, work with the employer to figure out the best avenue to go.
Thank you, Eric. Question here, if a manager finds an employee's accommodation request acceptable, is it mandatory or required to involve DTA in the case?
Well, that would be a form of accommodation, and like that's all that's necessary. Like if the manager, you know, provides the necessary accommodations, then the barriers are removed, you're satisfied with that, it meets your medical limitations, then you should be fine to go. I don't think any further sometimes it's a lot simpler and your manager is able to do it, but other times they'll involve, you know, the various you know, like each department and employer have different bodies responsible for the duty to accommodate. They have like specific areas that look over that. It'll depend very much on the employer, but I've found that it's usually not required if it's something that's relatively straightforward and able to be done by the manager. They might run it by that body that looks after accommodations to make sure that they're in compliance and that sort of thing. But for the most part, I don't see an issue with that, but it would depend on the situation, of course. And you'll hear that a lot from my answers. It'll depend. Accommodation is very individualistic, and every case is different and depends on the specifics of that situation.
Thank you.